A comprehensive report on the topic of getting your credits back from corporations, explaining the foundations, processes, and strategies behind asserting your position as the original creditor. Getting your credits back from corporations. Reclaiming your position as the original issuer of value. 1. Introduction. In modern finance, individuals are unknowingly treated as debtors in a system fueled by credit and commerce. However, under commercial law and trust theory, many believe that the living man or woman, you, is the true creditor, and that your legal name, all caps entity, is merely a corporate fiction created to interact with governments and corporations. This report explains how to assert your status as the original creditor, reclaim credits issued in your name, and use commercial, trust, and Uniform Commercial Code, UCC, strategies to pursue equitable return of those credits. 2. Understanding the legal fiction, strawman. What is the strawman? When you're born, a birth certificate is issued. This certificate is used to create a corporate entity in your name, often referred to as the strawman or ens legis trust. This entity, e.g., John Doe, is not you. It's a legal fiction used by banks, courts, and corporations to interact with the commercial system. You, the living man or woman, are the beneficiary and creditor, but the system reverses the roles, making you believe you're the debtor. 3. The role of credits. And your trust account. Credits are created in your name. Every loan, government bond, or public obligation is backed by your signature and social security number, which gives rise to negotiable instruments. Under HJR 192 of 1933, the U.S. removed lawful money, gold/silver, and mandated that debts be discharged through credit, not payment. Corporations use your legal name to draw credit from your exempted trust account, your CUSIP-linked estate. You are the original creditor. Your labor, energy, and participation in the system creates value. That value is monetized without your knowledge and transferred to banks, corporations, and the government. The remedy? Assert your role as issuer of value, and reclaim or offset what was taken. 4. Key legal foundations. A. Commercial law and UCC. UCC 1308, Reservation of Rights, you never waive your rights by participating in commerce. UCC 3305, holder in due course status allows you to challenge instruments issued in your name. UCC 1103.6, equity and good conscience still apply in commercial matters. UCC 1 Financing Statement, used to register a security interest in the legal name and claim priority. B. Trust law concepts. The strawman is a public trust, and you are the beneficiary. Governments act as trustees, and corporations benefit as third-party debtors. If you do not claim your rights, others will administrate your estate. 5. The process of asserting creditorship. Step 1. Secure your status. Record a UCC 1 financing statement with your Secretary of State. Add UCC 3 amendments to include collateral descriptions, your legal name, accounts, and rights. Declare yourself the secured party creditor and the living being. Step 2. Notice of creditorship. Send affidavits and notices to corporations using your credits, banks, IRS, utility companies, etc. Declare your status and demand an accounting. Use notarial protest and registered mail for legal standing. Step 3. Request for stetoff or discharge. File commercial presentments and bills of exchange. Demand return of the credits or offset of the obligations. Optionally use a 1099-A or 1099-C process to acquire or cancel debt. Step 4. Enforcement. file affidavits of non-response, notices of fault, and default judgments administratively. Record liens against corporations that fail to return credits. Escalate to commercial lien enforcement or private arbitration if necessary. 6. Sample notices and documents. A notice of status as creditor declares you are the secured party, acting on behalf of the estate. B. Notice of fault and opportunity to cure gives the corporation a deadline to respond or provide accounting. C. Conditional acceptance allows you to accept their offer, e.g., bill or loan, upon proof of valid claim. D. Bill of exchange, promissory note issued under your signature as credit, backed by your private exemption. E. Commercial lien or UCC lien filed when the opposing party fails to settle or account. 7. Frequently used tools. UCC 1, UCC 3 filings, notary certificates of dishonor, affidavits of truth 1099A and 1099C filings, 1040 volt vouchers for stetoff, private trusts and INS, registered mail numbers for chain of custody. 8. Risks and considerations. This is an administrative process, not a legal one. It requires precision and understanding. The system is not designed to recognize you easily as creditor unless you act with lawful authority. Misuse of these strategies, such as issuing fraudulent 1099s, can lead to legal consequences. Work with mentors, private groups, or lawful guidance when possible. 9. Final thoughts. Getting your credits back from corporations is about reclaiming your position as the source of value. By understanding the legal structure, trust dynamics, and commercial process, you can begin asserting your rights as the living creditor, not the debtor. This journey requires self-responsibility, study, and lawful execution, but it restores your rightful place in commerce.